Welcome to Environmental Law course, dear learner and viewer. We are going to discuss about the common law remedies for environment protection in India. In the last lecture, we devoted to the common law remedies for environmental protection. In a natural sequel to this lecture, we are going to discuss the common law remedies for the environment protection under the law of negligence and strict liability, because these are two major areas of the common law remedies which has been applied across the law of tort and as well as the law of crime, and it has resulted into the massive arrest of the pernicious tendencies of environmental pollution, and it has created a kind of a very salutary impact in promoting the sustainable development in the colonial India, and as well as in across many jurisdictions of the world. This law is still very relevant and have been frequently applied to contain all kinds of the pollution and to promote the goals of sustainability. In this respect, dear learner and viewer, we are going to discuss the very aspect of the law of trespass, which we have already discussed, but we are going to discuss something like on the law of negligence. So, law of negligence is a very important law in the sense that we discuss in the law of tort something which is based on natural law theories of jurisprudence. And when we talk of the natural law theory of jurisprudence, then it means that the law of negligence happens to be a kind of a duty oriented law. And it is because of these two merits, the law of negligence, under whether it is law of tort or it is whether it is the crime, in both respects the law of tort is considered to be the one of the major areas of common law remedies of environmental protection. And we see that the negligence, which is said to be a failure to do what a reasonable and prudent person would do, or doing what such a person would not do, it deals with some unintentional conduct that result into some harm and injury, and it is based on a fiction of the ordinary prudent and the reasonable man, that you have to exercise all care and caution as a reasonable man, as an ordinary man, as a prudent man, and from your behavior and standard, it is expected that a standard of care which is to be applied, which is to be considered, must be applied, failing which that the law of negligence comes into action. In this respect, we see that law of negligence and law of strict liability is a law, on the other hand, where there is no sense of any kind of an intention, there is no sense of a guilt, and without any kind of an intention and guilt, but there are certain practices which are absolutely makes parties liable and responsible if it causes harm to environment, and then whether it is intentional, unintentional, whether it is negligent or diligent, it ensures at the same time a prompt compensation and deterrence at all the levels. So these two aspects of the common law remedies are very important. Although we have the law of trespass, we have law of trespass, we have riparian right and prior appropriation under the common law remedies, but we will be devoting to first and foremost on the law of negligence, because the law of negligence by definition is what we can understand is the failure to do what a reasonable and prudent person would do. So the law is primarily a kind of the standard behavior, and this standard behavior does not like negligent behavior, and it always try to expect a diligent behavior of a person, as we have seen in the last slide that it is based on a legal fiction, and the legal fiction is that you have to behave as a reasonable person, you have to behave as a prudent person, you have to behave as a ordinary man of prudence, and you have to exercise all care and caution. And then by doing any action, what are the basic constituent that it deals with unintentional conduct, but there is certain harm and injury which has been inflicted, then it is based on the reasonable man rule, as we have discussed about the standards of care. The standards of care is not something which is very ideal, and neither it is very something low, but it is something which is practical, and this practical aspect is discussed under the law of negligence. And then this practical aspect is the standard of care which is expected of a reasonable man. And therefore, once the man have not discharged a reasonable man, and the reasonable prudence and the unintentional conduct have created some harm and injury, then there is some kind of a damages, and once the damages are accrued, then we will try to see that whether it is a proximate cause or it is a remote cause. So the proximity and the remoteness of the damages has to be established. This principle of negligence is very important by our understanding in application to environmental cases, and how it can be applied to the environmental cases, we will be looking at a very critical perspective. The critical perspective is that what has been said about the basic precept and the postulates of the law of negligence in the environmental context, it is very important. If somebody is careless disposal or handling of any hazardous substances, and then it has given rise to principles of neighborliness that we can discuss in slides to come, when we will be discussing the case in point that is known as Ryland versus Fletcher, a decision of House of Lords of 1867. Then here it is suffice to say that in the environmental context, how negligence law happens to be a very important constituent of the common law remedies, that it can be applied to any kind of a careless disposal, any kind of a mishandling, any kind of the behavior which have not exercised all due diligence. If the due diligence has not been applied, then it can be sued, and then the court recognizes and fixes the liability even if the government regulations permit, and its non-compliance is prima facie an evidence of fault, and then the non-compliance, once taken it is an evidence of the fault, then we see that the law of negligence works on the basis of the one constituent is the one and first ingredient of the law of negligence, that you are under a duty to take care. And once this duty to take care, now here the question arises that this duty to take care is very important in the sense that but the question is that we can reasonably ask that who imposed this duty to take care. And that's why you see that in the beginning I have mentioned that it is a natural law theory, it is a natural law proposition, and the natural law proposition is that not only it is a natural law proposition, but it is also a duty-oriented law, meaning thereby this law of negligence is speaking from the vocabulary of right. No, it does not speak in the vocabulary of right. It speaks in the vocabulary of duty. It is something very strange to note here, that this is a law which is not going to speak in terms of the right, but it is a law which is going to be enforced in terms of duty. And this duty is from where this duty has been imposed, that the source of this duty is not known. and the source of this duty, once it is not known, that what is the source of duty is not known. Even though the source of duty is not known, that the law of negligence applies. So the first and foremost aspect of the law of negligence, that without knowing, without bothering, without understanding, without going in the intricacies, that who imposed this duty, we take this law on its own face, and we try to see that whether there is a failure, whether there is a kind of a behavior which was unreasonable, whether there is a kind of a behavior which is not expected from a prudent man, whether there is an intentional conduct or unintentional conduct. What we are going to see, that there is some kind of non-compliance, there is some kind of a prima facie evidence of fault, and it says that it is the duty to take care, and that duty to take care, which again I will emphasize on the point, that is important not in the sense of the private person, not in case of public, not in case of community, but in case of a state, because this duty to take care of the law of negligence is important in the sense that it recognizes the principles of neighbor. It recognizes the principles of neighborhood in private terms, in public terms, in community terms, in state terms, and then we can understand that what is transboundary impact of environment. So to a particular neighbor, to particular neighbor, to public at large, to community at large, to a state in general, that if any kind of activity which tries to be fit into the basic precept and the postulate of the law of negligence, then we can create a kind of a situation that we have to simply establish that there was a duty to take care, and that's why we again repeat for the sake of reiteration that the source of duty is not known, and it is a kind of a natural law that you have to behave in a particular way. It is a duty oriented law, it is not a right based law, and once it has been established that you have a duty to take care and there is a breach of duty. So the breach of duty is something is very important, because the breach of duty means that, as we talk of in terms in terms of trust, in the law of trust, we also use the word like breach of trust. Similarly, the word breach is very important, and we should give emphasis to the word breach. Here also, what we say, what it encompasses at the basic ingredients of the law of tort is the fact that there is a breach of duty. Even though, again I'll be repeating that even though the source of duty is not known, even though that we do not talk in terms of right, because most of the law of tort speaks in the vocabulary of the right, and as the constitution speaks in the vocabulary of right, then law of tort also speaks in the language of the rights, in the vocabulary of the right, but law of negligence speaks from the language of duty, and duty was to take care of the neighbor, of in private property, private person, public, community, state, and there is a palpable and evident prima facie evidence of the breach of duty, then then we go for the causation of that duty. Yes, we can understand that what is proximate, we can understand what is remote causes of the duty, but again the third important ingredient is that though there was a duty to take care, there has been a breach of duty, and then there are damages. Once the damages are so evident, then we can only apply the law of negligence, and damages are also of two kinds. The one damage is something, one is evident damages, which is glaring, meaning thereby res ipsa liquiter, that it does not require any kind of an evidentiary value because the circumstances speak of itself. The damages are so of such a horrendous magnitude that we do not require to prove it that there are damages. The damages are very evident, glaring, conspicuous, and in that case that we can talk of the damages as one of the important criteria. And here in the issue of the damages, again we can apply to talk of damages, then we can also apply to the idea of what is called is the quantum Mario. The quantum Mario is that it talks about the measures of damages. It talks about the proximate as well as the remote consequences of the damages. So, the last ingredient of the negligence is also very important in giving our understanding to law of negligence. So, the common law remedies to environment protection under the law of negligence is also one of the very important law, simply because of the fact that the proof of this negligence is very easy in matters of environmental damages, environmental harm, regardless of any kind of an intention or unintention or guilt, and it is a kind of a breach of duty. It is a kind of a, we are not supposed to go into detail the causation, but certainly for the measures of the damages we can have the causation into effect and take into cognizance and consideration. And then the damages are also of two kinds, the one the remote and the proximate, and as well as there are damages which are said to be res ipsa liquiter, which are so evident and glaring. In having understood the entire ingredients of law of negligence, then we will try to see that how its non-compliance attract condemnation under the law of negligence in tortious and as well as in the Indian Penal Code. Therefore, after having studied the ingredients of law of negligence as a common law remedy and its application for environment protection, we will move to the Indian Penal Code 1860, which also recognizes negligence as a vital element of common law remedies, and it is applied frequently on matters of environmental pollution and hazardous substances regulation. It applied primarily to address criminal negligence in handling poisonous and dangerous substances. And if we peruse from section 284 to 288, then we find a kind of a catena of the circumstances which give rise to the negligent scenario under the Indian Penal Code, be that negligent conduct with respect to explosive substances, be that negligent conduct related to the combustible matter, be that the negligent conduct with respect to the machinery, be that the negligent conduct relating to pulling down of or repairing of the building, or any kind of the lastly, which is very important, and it is important because this section was likely to be applied, but it's a great opportunity which was lost in the case of one of the most important environmental catastrophe in India, that is known as the Bhopal case. This the section 304A, that causing death by negligence, where the 4,000 people died on the 2nd and 3rd December 1984. So then we see that a display of the negligent behavior which has been conceptualized and enumerated under the Indian Penal Code 1860, 284, 285, 286, 287, 288, and most notably section 34A of the Indian Penal Code. In this way, we see that Section 3.4, the circumstances number 1 is the section 284 to 288, and then circumstances number 2 is what is called that number 1. Number 2 is 304A, that penalizes death caused by the negligence, and it was applied notably in Bhopal gas tragedy case. And then we see that the fines and punishment, which varies from case to case, it has a different kind of a fine and imprisonment mechanism, whereas this case has a different kind of a fine and case. Here, the attention is also drawn to the fact that what has been applied as section 304, then 304A of the IPC, what it talks of, in law of tort, in matters of negligence, it is known as mass tort, and this mass tort was applied in the case of multinational companies liability. And here we can mention few works of Professor Upendra Bakshi, that multinational liability and the catastrophe, Bhopal catastrophe, or convenient catastrophe, an inconvenient forum, a series of 2-3 books which has been authored after the Bhopal tragedy in 1984, and which tries to see at detailed law on the Bhopal gas tragedy and multinational liability, and speaking about the mass tort, whether it can be applicable under the Indian circumstances, meaning thereby this is in law of tort, this is in law of crime, can both be applied to a situation or a kind of a catastrophe of a magnitude of the Bhopal gas tragedy. That remains a question to be answered when we discuss the relevance of the common law remedies for environment protection under the law of negligence. With this, we can say that the law of negligence is very important either in the domain of law of tort or either in the domain of law of crime, as the basic law is the Indian Penal Code 1860 and the perusal of section 284 to 288 of the Indian Penal Code vis-a-vis section 34A, that penalizes death caused by the negligence of any kind of a company who have brought the hazardous substances and hazardous operation, and in case of Bhopal precisely that the methyl isocyanate which escaped out of its plant, how the law of negligence can be applied to such cases. With this, we have also seen the provisions, and we also try to see the procedural part, that how this criminal negligence can be applied through the mechanism of section 133(1)(d) and of the Code of Criminal Procedure 1973. Then we will try to see that how the case of law of negligence happens to be a kind of a law right from the doctrine which was laid down in by the Renan versus Fletcher. Is now we are moving to a case that this law was applied in Renan versus Fletcher, and Renan versus Fletcher in this by House of Lords is a very monumental decision of 1867, and even down to this day that this decision of the House of Lords is well respected and serves as a basic precedent to guide law of negligence and as well as the law of strict liability. And then we see that anyone who bring the hazardous substances in the premises, and then simply once it has been brought to the premises, it is liable for the damages. Here, the sense of strictness of the law of negligence, that besides it has relevance in the law of negligence, that you have to observe the principle of neighbor, that you cannot bring any kind of hazardous substances. Why? Because you have a duty to take care. You are not supposed to commit a breach of duty. And then you have to act as a prudent man. You have to act as a reasonable man. You have to act very cautiously. And if there has been a failure and there are the damages, then this part was taken into consideration into Renan versus Fletcher case in 1867, and thereafter, once it was applied that it was a sheer case of negligence, then the House of Lords have moved beyond and have laid down the principles of strict liability. Why? Because you have brought the hazardous substances on the land and you were knowing that it was liable to cause damage, and you alone has the capacity to see that how the care is to be exercised, and then you miserably fail in exercising the care, you committed the breach of the duty, and then there are certain damages, then you are liable strictly. So we move from common law remedies of law of negligence to law of strict liability in case of Renan versus Fletcher. The other case happens to be the Buden versus BP Oil and Shell Oil Company Limited in 1980, where the parent claimed harm to children from petrol refining emission, and it was also brought in a Control of Pollution Act of 1974 because it's a case of a foreign jurisdiction and this is not an Indian law on the point. Nonetheless, we see that besides the having a statutory law on the point, that the same doctrine of negligence and strict liability are applied, meaning thereby what comes out of it is the fact that for application of the common law remedies for environment protection under the law of negligence and the law of strict liability, what is important that even if there are certain statutory law which are applied alongside, concurrently this law can also be applied, as the case of Buden versus BP Oil and Shell Oil Limited case suggests, and then it tries to see that how public interest justified regulation, but the companies still owe duty to take care of whatever has been done under the Control of Pollution Act is something different, and what is the duty which has been cast under the law of negligence. If it has been miserably failing, the company is miserably failing, then it attracts the strict liability principles. That way, we see the strict liability principle is there are three ingredients and principles that if you have a non-natural use of land, as it happens in the case of Reliant versus Fletcher. Reliant versus Fletcher has, in this case, the House of Lords have examined and established that this is non-natural use of land because somebody has brought dangerous substances and it has escaped out of that, then the principles of strict liability is applicable. Therefore, what we see that besides the law of negligence, the one step further, the law of strict liability happens to be a very relevant and handy mechanism, in giving effect to an abnormally dangerous, palpable activity which can be hazardous, which can be deleterious, which can be harmful, and thus it can be universally applied to all kind of environmental harm. And therefore, what we can see that whether it is storing, whether it is transmitting, whether it is drilling or spraying kind of a crop, any kind of the activity relating to water, relating to gas, relating to air, all kind of environmental harm which results from non-natural use of land, dangerous substances are brought within the premises, it escapes, then the principles of strict liability is applied vis-a-vis the principle of negligence is also applied in that sense. And that's why that we see that although there are certain defenses which has been applied to all cases of strict liability, we have this kind of the defenses which are available. The act of God is there, act of third party is there, the fault of the plaintiff, contributory negligence is there, some kind of an statutory protection, and the exceptions are also there, and some kind of a consent of the plaintiff. It is probably one and the same or something related to one and the same, but what we see that it recognizes certain exceptions, and if anybody tries to escape the strict liability, can raise the bogey of the exceptions and the defenses which are available. But in most of the cases, it applied to the toxic and hazardous pollutant where parties are enforced even without proof of fault. How it has been proved without the fault? Because as we have discussed earlier, that there is a doctrine res ipsa liquider. If the catastrophe, if the damages are glaring, if the damages accrued has been so evident, then it does not require any kind of a proof, and without any kind of a proof that both law, the law of negligence and as well as the law of the strict liability are to be made applicable. And then what we see that they are not only be held liable, but we have to clean up the cost. Here, what we talk of polluter pays principle, what we call of precautionary principles, we see that whatever the modern set of international environmental law has handed in due course and afterward in the 19th and 20th century, we see the replica and the glimpses of this polluter pays principle here in the law of strict liability, here in the law of negligence, and then what the precaution principles are there. This is the precautionary principle. In fact, when we say the non-natural use of land, dangerous substances, escaping principles of strict liability, then it is the point where we can see that there is a precautionary principle. Thus, what we see that despite having a kind of a relaxation of exceptions and the defenses, we see the law of negligence and law of strict liability has been one of the most vociferous articulation of the common law remedies for environmental protection, and it has a very pragmatic application in cases of all kind of pollution, all kinds of hazardous substances, all kinds of obnoxious activities, and all kinds of environmental damages and harm which has been accrued. These two sets of law of negligence and strict liability under the broad canvas of the common law remedies for environmental protection goes a long way in bringing the defaulters to terms, and in bringing it comes very heavily to one who violates these laws by paying unliquidated damages, compensation, remediation, and try to get the cleaning of the environment and cleaning up the cost. Then in real sense, we see that the modern principles of polluter pays principles and precautionary principles are also having a great sense of recognition much prior of its articulation at the later point in the environmental conventions and statute and the international environmental law. With this, my dear learner and viewer, I hope that when we are discussing the common law remedies for environmental protection, our discussion on common law remedies for environmental protection under the law of negligence and strict liability will deepen our understanding to see that how the environmental liability question can be best addressed under the premise of law of negligence and strict liability. With this, I thank and wish you a happy learning.